The next session is hosted by Shardul Amarchand Mangaldas. The topic of the session is Too Much, Too Little, or Just Right? Rethinking Scrutiny of Awards Across Jurisdictions. The session will be moderated by Shreya Jain. The panelists include Abraham Vergis, Kanika Goenka, Honorable Justice Nageswara, and Mr. Sudhanshu Swaroop. Thank you.
Welcome to the panel discussion, the last panel discussion for today on the topic Too Much, Too Little, or Just Right? Rethinking Scrutiny of Awards Across Jurisdictions. The session is sponsored by Shardul Amarchand Mangaldas for this ADR week today. My name is Shreya Jain. I'm a partner in the dispute resolution team at Shardul Amarchand Mangaldas, and I'll be your moderator for today. The topic we are discussing today is the scrutiny of supervisory courts in review of arbitral awards. We often hear the words minimum curial intervention, minimum judicial intervention being thrown around as a key ingredient of what constitutes a good arbitral seat. However, as practitioners and users of this system, we all know that it's not as simple. Seat courts provide a very critical oversight mechanism in arbitrations, particularly at the stage of challenges to arbitral awards, and they bring confidence to the users in the arbitration process. The question, therefore, is one of balance. What and how much scrutiny should be applied by courts, which is what we'll focus on further today in today's session. So, without any further ado, I'd like to take this opportunity to welcome our panelists for today. They really need no introduction, so I'll keep it very brief. So I have in the middle Justice L. Nageswara, former judge of the Supreme Court of India. He's also a former senior advocate and Solicitor General of India and sits as an arbitrator in domestic and international arbitrations, both ad hoc and under all major institutional rules. To his left, we have Sudhanshu Swaroop KC. He is a barrister and King's Counsel at 20 Essex Chambers. He specializes in arbitration, commercial disputes, as well as public international law matters. To my left is Abraham Vergis, Senior Counsel. He is the founder and managing director of Providence Law Asia, Singapore. He regularly appears in domestic and international arbitrations, as well as Singapore courts and the SICC. He also sits as an arbitrator and mediator. And last but not the least, the lady at the center, we have Kanika Goenka, partner at Shardul Amarchand Mangaldas. She also focuses on domestic and international arbitration and complex global commercial litigations. Prior to joining SAM, Kanika worked for several years in the dispute resolution team at major firms in Mumbai. So, in terms of structure for today's panel, this would be a free-flowing discussions without any formal presentations by any of the speakers. The idea is to have a free-flowing conversation and end with some questions from the audience. I will briefly introduce the topic that we are discussing today and then ask our panelists a few questions. And we'll try and reserve the last 10 minutes for audience questions. So today's discussion would follow two themes. The first theme, which we'll begin with, is the standard of review to be applied by the curial courts when reviewing an arbitral award, particularly when the award is challenged on jurisdictional grounds. And the second theme, which we'll end with, is the power of a review court to modify arbitral awards, a topic we are all very familiar with based on recent developments. With this, I'd like to move on to the first question, and if I could request Justice Rao to weigh in on this. So, in your view, what are the risks and considerations that need to be balanced by a supervisory court when reviewing arbitral awards?
Thank you, Shreya. I see a fair number of Indian lawyers and legal professionals in arbitration and a number of other people from outside the country. I was asking Shreya as to whether I should speak about the domestic arbitrations and what the courts do here, as well as what the domestic courts do in international arbitrations and enforcement of awards as well. She said it would be a good idea to speak about what the supervisory courts do and what are the considerations that are taken into account for reviewing awards, even in domestic arbitrations. The lawyers from India might know what I'm going to tell you. The others this might be news to you. The structure of Indian courts is such that we have about 34 Supreme Court judges and we have about 1,079 High Court judges and about 25,000 judges at the subordinate judiciary. Out of these 25,000 judges, there are about 4,000 district judges and additional district judges. Review of arbitral awards, they would go to any of these 4,000 district court judges, district court as well as additional district courts. And wherever there is original jurisdiction like Bombay, Delhi, Chennai and Calcutta, including Shimla, the high courts review the arbitral awards. The considerations for a supervisory court while reviewing awards is clearly laid down in the Arbitration Act 1996. They need not search further. The amendment that has been made to the 96 Act in 2015 on the basis of the Law Commission recommendations makes it very clear that there should be minimum intervention when it comes to arbitral awards. So the intervention in arbitral awards by supervisory courts is restricted to only those grounds that are mentioned in the Act, no further. And wherever there is some confusion, assuming there is some ambiguity as to the terms that are used in the provision in the Arbitration Act, like Section 34 says that review is permissible on grounds of patent illegality. There might be a problem of judges understanding what patent illegality is, what is the scope of this phrase patent illegality, whether court can interfere or not. There is sufficient guidance from the Supreme Court in terms of judgments that were given by the Supreme Court as to what exactly is patent illegality. There is absolutely no problem in understanding the scope of patent illegality if evidence is not there at all, or if there is a misreading of evidence. There are 3-4 instances that have been given in at least 4 or 5 judgments as to what patent illegality is. Wherever the Supreme Court had a chance of looking into the role of the supervisory courts in taking into account the relevant considerations for interfering with an award, it has been repeatedly saying that interference on merits is not permissible because that is the legislative mandate. It is very clear insofar as domestic awards are concerned that there is some leeway for the supervisory courts to interfere on this ground of patent illegality, which is not available for international awards. There are international arbitrations where the seat is India. They are also covered by Part 1 of the Arbitration Act. But the Act makes it very clear that patent illegality is not a ground for interference and perversity is also not a ground. So what is the ground then? The ground is only jurisdiction, which means that the arbitral agreement is non-existent or the constitution of the arbitral tribunal is not made properly, or otherwise the arbitral tribunal has traversed beyond the reference that is made to them. So these are the grounds which have been mentioned. Apart from certain grounds that are available to a party, if the party says that I have not been heard, violation of principles of natural justice, and thereafter public policy grounds which are available for a domestic award. Now moving on to enforcement of awards, because enforcement of foreign awards also go to not only courts in Mumbai or Delhi, they go to any district court because wherever the assets are situated, enforcement proceedings are initiated. They might be going to any district court in any corner of this country. So, Section 48 clearly lays down as to what are the grounds for enforcement and recognition of arbitral awards. And there has been a clear interpretation of this provision also by taking into account the objection reasons of the 1996 Act by the Supreme Court. And there is no review on merits, even when there is a ground of public policy that is taken, because public policy is one ground which is permitted even by the New York Convention. But the court has said, on a plain reading of the provision, that there cannot be a review on merits. All said and done, what is the problem then? The problem arises in law being very clear, but law not being understood by the judicial officers. As I said, there are about 800 districts in this country. So whenever an award is taken for an application which is filed for setting aside the award, more often than not, I hear from legal professionals that courts would try to enter into the merits of the award. I heard recently a judge of the High Court speaking in a public function saying that we look into the award and we know what to do. This is not what has to be done. The risk is that every judge, though he is legally trained, though he is told that the approach has to be a judicial approach, though he also knows that the discretion that he has to exercise is judicial discretion and not his personal discretion, according to his whims and fancies, but still, there is a tendency of judges not following the objects and reasons of the 1996 Act. And the risk, apart from all these considerations which I spoke about, the risk is not because of a judge not understanding what he has to do. Most of the judges who are discharging these functions of a supervisory authority are legally trained minds. If not now, after a few years, they should know what to do. The risk is to the institution of arbitration in this country. The risk is for encouraging arbitrations in this country, you need supervisory courts. It's not as if arbitration should be just left alone. The very reason for supervisory courts being there is to give an assurance to parties who choose arbitration that if at all there is something wrong, the courts are there. And when I said minimal interference is not no interference at all. So there is a need for training of all the High Court judges and the District Court judges. It's not that it's not being done. The National Judicial Academy regularly trains High Court judges. We have on 4th October, there is a session. I'm going to the National Judicial Academy to train High Court judges in arbitrations. What is it that they have to do? What is it they should not do? And there is a need for every one of us, we are talking about, I'm talking about judicial officers, I'm talking about even legal professionals as well, to be abreast with the latest position of law, to follow the law and ensure that the interference is limited, because taking into consideration all the factors which have been mentioned in the statute and judging whenever an application for set aside is being filed is a great job done. The risks that are attached to it is when a judge traverses his powers. Every judge knows what his powers are. Powers come from the statute itself. So this is what I can say on the risks, because there is no risk in an individual. The person who goes to court is at risk. The institution is at risk.
Thank you, sir. This is extremely insightful, and some of the things which you touched upon also sort of directly play into the theme that we are going to touch now, which is approaches and standards of review to be adopted by, in the Indian context, say a district judge or a high court who's sitting as a curial judge over an arbitral award. While the grounds of challenge to arbitral awards, like Justice Rao just noted, are largely harmonized across model law jurisdictions, including India, there are differing views on what standard of review should be applied by the court when an award is challenged, particularly on jurisdictional grounds. And this question is particularly relevant for jurisdictional challenges because of the principle of competence, which we are all familiar with. This entails two fundamental ideas, one being that the tribunal has the power to decide its jurisdiction first, before any court can rule on it. And the second, that given that it concerns the tribunal's own ability to hear the case, it cannot be the final arbiter of this decision, as that would become a classic case of, pulling oneself up their own bootstraps. And on this basis, several jurisdictions, both civil and common law, have applied a different standard of review to jurisdictional questions, known as the de novo standard. In practice, this entails a few key questions for the reviewing court. what is the evidential value of the arbitral tribunal's decision? Is the party who's challenging the award entitled to a full rehearing of the case? And if so, can the party go as far as introducing new evidence for the first time before the review court? These are just some of the questions we look to our expert panelists for ideas and sort of views on what is the trend in their respective jurisdictions. And we start with the English position first. And on that, Sudhanshu, if I could request you to take us through what is the standard of review applied by English courts to challenges to arbitral awards and in particular jurisdictional issues, and what is really the rationale behind applying different standards if that's the case.
Thank you. Where an arbitration is seated in England, there are three ways to challenge an arbitration award in the English courts. The first of those is an appeal on a point of law under Section 69 of the English Arbitration Act 96. And in that regard, there are just five brief comments I want to make. First, Section 69 provides that an appeal on law can only be made, quote, on the basis of findings of fact in the award. So recently in the Supreme Court case of Sharp and Vitera, the court held that that meant either there had to be an express finding of fact in the award or a finding that could be inferred, but only where that inference was inevitable from the express findings. It was insufficient if an inference was merely reasonable. And on that basis, they said that the Court of Appeal was wrong to find a variation of a contract which the underlying arbitral tribunal had not found. Secondly, in order to get permission to appeal on a point of law, you have to show either that the finding of the arbitral tribunal was, quote, obviously wrong, that's Section 69, alternatively, that the point is one of general public importance and that the finding is open to serious doubt. So that is a very big obstacle to anyone trying to challenge a point. An example of general public importance, for example, will be the construction of a standard form contract, which is in widespread use. Third, even where the courts give leave to appeal on law, they take a very hands-off approach. The words that are often quoted in these cases are the words of Bingham J, as he then was, in a case called Zermatt Holdings, which says that the courts do not approach awards, quote, with a meticulous legal eye, endeavoring to pick holes, inconsistencies, and faults in awards with the object of upsetting or frustrating the process of arbitration. And that thinking applies all the more if the arbitration is a trade arbitration, for example, an LMAA shipping arbitration or a GAFTA commodity arbitration. The court will defer to the reasoning of trade experts. Fourthly, in practice, it is rare for a Section 69 appeal to succeed. For example, in the year 23 to 24, there were 52 applications in the English court to appeal on a point of law. In those, 10 of those cases, permission was granted, and of those 10, only one was successful. I should add, of the 52, 19 are pending, but you can still see 10 permission granted, only one successful. Fifthly, around 10 years ago, there was a very spirited debate about whether we needed to reform our appeal on point of law. On one hand, you had Lord Thomas, who was then the Chief Justice, who argued we did need to reform. In particular, he said that the development of the common law was being stifled because of the number of commercial disputes that were being determined in arbitration without ever being ventilated in court. They were being, and therefore without the publicity that you get in court. In response, Sir Bernard Eder, a former High Court judge, argued that he was totally unpersuaded that private litigants should be forced to finance the development of the common law by pursuing appeals to the High Court. He observed that otherwise the logical extension would be to prohibit any party from settling any case where there was an interesting point of law at issue. I observed that our recent 2025 Act amendment has not sought to change the structure of 69 in any way. The other area, Section 68, jurisdiction challenges. So in these, a party can object to the tribunal that it lacks jurisdiction. A tribunal can make an award on substantive jurisdiction, and then that award can be challenged in the court under Section 67. The traditional position in England was set out by the Supreme Court in a case called Dalla, where the court said that any such challenge on jurisdiction in the court was potentially by way of a full rehearing, even if there had already been a full hearing in front of the tribunal. They said, furthermore, any ruling of the tribunal on jurisdiction did not bind the court and indeed had no legal or evidential value. And part of the principal basis for that was said to be that if the tribunal actually did not have jurisdiction, then its award should be of no status in a court. That was subject to one overriding principle of waiver, which is, in any event, a party, if you had an objection on jurisdiction, you were obliged under Section 73 of our Act to make that jurisdiction objection promptly. And if you didn't do so, then you would lose the right to raise that particular objection in court. We've just had a recent amendment, the 2025 Act, and that Act provides a power for the Civil Procedure Rules Committee of England to implement new rules of court to avoid a jurisdictional challenge becoming a full rehearing. In short, the new Act reaffirms the basic obligation to raise any ground of objection to jurisdiction promptly. It provides then that rules of court may be made, finding to the effect that new evidence that was not before the tribunal on jurisdiction may not be considered by a court unless a party can show that it acted with reasonable diligence in failing to put the evidence before the court. And it provides the new rule showing, finding that evidence that was heard by the tribunal must not be reheard by the court. The principle for this new approach is said to be both competence, that actually the recognition a tribunal does have the competence to rule on its own jurisdiction, and also one of due process, that when the tribunal makes that jurisdiction, it does so where both parties have had a right to put their full case. So the court seeks to strike a balance and find that the new regime will operate on the basis that the finding of the tribunal does have some status in English court. And finally, just briefly, Section 68, serious irregularity. This has been described by the House of Lords in the case of Lesotho, the leading case, as a long stop, only available in extreme cases where the tribunal has gone so wrong that justice calls for the matter to be corrected. And again, these are very rare. And in conclusion, as I've said, whether it's point of law, jurisdictional serious irregularity, there are really serious obstacles in the English courts in challenging an arbitral award. This can mean, in some cases, that errors go unremedied, but that is the price that commercial parties choose to pay for finality and for certainty. As Sir Michael Kerr, a former Court of Appeal judge, said some years ago, remember, when parties agree arbitration, they buy the right to get the wrong answer. Thank you.
Thank you, Sudhanshu. Those are words to live by. Just want to ask you one follow-up question on a point you touched upon, which is the recent amendments.
Yes.
And in particular, the power given to the Rules Committee to depart from, say, the de novo review set out in Dalla. Given that, the decision in Dalla was such a seminal sort of precedent, not just in the UK, but a lot of common law jurisdictions.
Yeah.
What do you think prompted this shift away to a bit more deferential approach, if I may say so?
Well, our 2025 Act was made as a result of a Law Commission report, and that Law Commission report was based on widespread consultation from international law firms, barristers, and others like insurance companies, all of whom are involved in the arbitral process. And I think, firstly, there was a general sense in practice that this can just involve a very costly rehearing of a matter that's already been decided once as a matter of practice, but also that there were strong principled reasons that had been ignored in Dalla for this new approach, namely competence, and also the due process point, that you've already had a fair hearing once. Why should you get the second bite of the cherry? So they wanted to strike a balance between the Dalla approach and a new regime.
Understood. Thank you for that. If I could now move from the UK to another common law jurisdiction, which is Singapore, and Abraham, you're sort of our expert here. How does Singapore law deal with the question of standard of review? Are there different standards applied for different grounds to challenge awards? And what do those standards entail in terms of what evidence can be led before the supervisory court?
Yeah. Thank you for that, Shreya. Very good evening to everyone. It's great to be back in Mumbai. So in Singapore, we have essentially the standard of de novo review when it comes to jurisdictional challenges. And as far as all the other traditional scope for challenges, whether it is a scope challenge or fair hearing challenge or breach of natural justice challenge, there we are really looking more towards the process that was undertaken at the hearing, as well as the conduct and the determinations made by the tribunal. So there, it's not going to be a de novo hearing. It's really going to be focused on what actually transpired in the hearing as is, right? Now, coming back to jurisdictional challenges, when we say it's going to be a de novo hearing, we took that language from Dala, but we sort of put a new spin on it in the sense that when we say that the decision of the tribunal on jurisdiction has no legal and evidential value, and therefore the matter should be reheard de novo, how we've interpreted in Singapore is like this. We say that the tribunal's decision in having no legal or evidential value means that the Singapore courts can now look at the question of jurisdiction afresh, completely unfettered, by the way in which the tribunal had gone about deciding the issue. Although in Singapore, the courts take the view frequently that the decision of the tribunal and how it arrived at that decision is something that the court would look at with interest and very carefully. It has no binding value, but it is something that the court will take on board as a matter of judicial assistance, right? But it is free to make its own independent decision on that outcome. So that's the first point. The second point is, what do we mean when we say that the matter will be considered de novo or afresh? We have basically, in essence, taken this view that not every case will it be required for the court to have an entirely new hearing and take on oral evidence and cross-examination of witnesses. In fact, in most cases, there will be no need for that. Instead, it will be in exceptional cases where the court may consider that based on the basis of the challenge, it may be relevant to take on board further evidence and, if necessary, to actually conduct a trial on this issue. And that's an important distinction. The Singapore courts, if I can boil it down, we take a very pragmatic approach when it comes to jurisdictional challenges. We have judgments that go to the effect that now with verbatim transcripts, the court hearing the matter would have access to the same evidence that was before the tribunal, and therefore this negates or militates against the need for the court to have an entire hearing on the same evidence. So the fact that you've got verbatim transcripts is a point in favor of not rehearing the whole thing. And secondly, when you make an application for jurisdictional challenge, under our rules, you're supposed to put in not just the arbitration agreement and the award, you're supposed to put in the entire record of proceedings, which includes pleadings, witness statements, submissions, as well as transcripts. And so the Singapore courts have said, now that we have all of this entirety of documentation that was before the tribunal when it made this decision, this should be, in most cases, sufficient for us to consider the issue. And that's how we have proceeded with this question of de novo hearings. I bring now to your attention a case that actually came out of arbitration held in India, where I was instructed with Indian Counsel to challenge in the SICC in Singapore. And that was the case involving Reliance Infra and Shanghai Electric. And there, what had happened was Reliance Infra, having lost the arbitration and had an award entered against it for about $130 million, sought to challenge the tribunal's jurisdiction on the basis that the guarantee agreement upon which it was sued was not signed by any of its people, and the signature of its employee that's ostensibly on the document is a forgery. And therefore, they say non as factum, there's no agreement, and therefore the arbitration agreement that's contained therein was not valid and enforceable. Now, the argument was that that particular employee at the time of the arbitration had left Reliance Infra and joined Adani Group, and therefore was not in a position to assist in the matter and was refusing to come forward as a witness. And without that person's evidence, they were not in a position to run the argument of fraud. And additionally, they said that all their records showed that none of them had ever had this document in existence in their records. So there was this entire question of whether this new allegation of fraud and forgery in the signature would invalidate the agreement to arbitrate and therefore be a basis to challenge jurisdiction. And interestingly, because all of this was put into the affidavit in support of the jurisdictional challenge, the SICC, which heard the matter, actually agreed that there would be a trial on this issue of forgery. And as a consequence, you had 3 witnesses of fact and 2 expert witnesses that actually were cross-examined in the course of a 3-day trial. And as far as I know, this is the first instance in Singapore, at least, where you actually had a full trial on the issue of forgery in the context of a jurisdictional challenge. Of course, to balance the prejudice to the award creditor, the court imposed incredibly strict timelines, Singapore style, if those of you who are familiar with it. And just to give you a sense of it, we had a 3-day trial, 5 witnesses, including 2 experts. And we basically had to spend half a day with opening statements, 2.5 days with the cross-examination. And after lunch on the 3rd day, the court asked that we go directly into oral closing submissions. No written submissions, you just submit orally at the end of this 3-day express trial. And the court issued its decision on the matter 3 weeks later. Right? To give you a sense of it, in Singapore, the SICC president has said in user council meetings that SICC is committed to have all challenges to jurisdiction and all these enforcement challenges dealt with within 6 months. That's the KPI that they want to dispose of these challenges. And so for those of you, who have ongoing matters and are concerned about challenges in Singapore, 6 months is about what you can expect in terms of the time it will take to conclude at least the first round or the first instance before the SICC. In our case, the matter took something like 11 months, but exceptional because of the need for the trial. So that's an important point to bear in mind. And I give this example just to make another point, which is Singapore has a strong reputation for being very pro arbitration. And I discovered recently in a trip to Dubai that actually the DIFC courts is even more stringent than Singapore. I discovered, for example, that in the last 21 years of the DIFC court's existence, there's actually never been a successful challenge to an award, either for jurisdiction or for any other basis. No award has been overturned in Dubai. So in Singapore, yes, we have a very strong pro-arbitration stance. But as this case demonstrates, in the appropriate case, the court will at least entertain the argument and, if necessary, even hold a mini trial. But as I've demonstrated, it will happen very, very quickly. Now, as far as the other grounds for challenge, again, the basic rule in Singapore is, again, we take a very pragmatic approach. It's minimum curial intervention. But if I can summarize it this way, whether it's a scope challenge or whether it is a fair hearing challenge, the courts are not going to accept what the court describes as disguised attempts at substantive merits challenge, right? So if you look at the recent decision of Justice S. Mohan in the Swire and Aces case, he gives several examples, and that's a great case to look at, where the court sort of dissects all the complaints of breaches of natural justice and what have you, and strips it down and says, look, you're really just complaining that the tribunal didn't agree with your arguments. And that's not going to be a basis for a challenge. As far as Singapore is concerned, we never question the correctness of a decision. We are only concerned to ensure that the bargain that the parties had signed up for when they signed an arbitration agreement, which is to be part of an arbitral process that is fair, that is impartial, and that is equal, that bargain is upheld. We are not interested in the correctness or the merits of the decision. Thank you.
Thank you, Ibrahim. These are great stats to have on hand, and they've inspired me to have a DIFC practitioner next time on the panel too. If I could just ask you a very quick follow-up question. You've heard about the recent English amendments. Do you see Singapore adopting a similar approach in terms of legislative amendments?
So Singapore has actually recently put out a public consultation in view of the amendments in England. And it is now looking at a couple of issues, one of which is whether the de novo hearing standard needs further clarification. My own personal view is I think our approach is already quite tight, that I don't see a need to tighten it any further, if you will. As I said, the default approach is most of the time you wouldn't need a full-fledged rehearing, but in exceptional cases, we will allow for it. And to my mind, that has worked pretty well. There has also been questions about whether they should be, let me just see if I have it here. Whether they should be the determination of the governing law of the arbitration agreement. In Singapore, the position used to be, we look for express choice, implied choice, or what law has the closest connection. Now we are considering the English position, which is simply to take the law of the seat as the governing law of the arbitration agreement. Yes. And then the question of whether there should be appeals on points of law And there the question is whether it should be with leave of court. An interesting question is whether it should be confined to points of Singapore law or whether we would even consider an appeal on points of foreign law. And the third modality they're looking at on these points of law is whether they should now give parties an option in their arbitration agreement to opt in for a reservation of a right to appeal on points of law. So, in other words, to throw it to the parties to decide upfront whether they want to consider this as an opt-in add-on, if you will.
Very interesting issues, and we'll wait to see the position that Singapore ultimately takes. Finally, moving on to the Indian position, Kanika, could you let us know how the Indian courts have dealt with this question, if at all, on the standard of review of different grounds of challenge under Section 34, including a focus on jurisdictional challenges?
Thanks, Shreya. So, Sir touched upon this, and I would very quickly elaborate the position in India. Of course, the Indian Arbitration and Conciliation Act of 96 is based on the model law, and the grounds that are available to challenge your award or to enforce a foreign award, again, mirrored model law. The grounds that are available to challenge an award under Section 34 or which are available under Section 48, which essentially deals with enforcement challenges, are largely kind of split, into two. So the first bucket, as it were, is essentially your procedural and jurisdictional challenges, incapacity of either party, invalidity of the arbitration agreement, or natural justice, a party didn't have enough opportunity to present its case. Or then you have the second bucket, which is essentially substantive challenges, your public policy. Just like in model law, the Indian Arbitration Act sets out the grounds for challenge, but it doesn't tell you what the standard of review is. And to ascertain the standard of review, you would have to look at jurisprudence. And there is honestly it's a long story, the Indian jurisprudence on, what the correct standard of review is. And it sort of dates back. So very quickly, the position pre and post 2015 is quite different, as Sir also said. Pre 2015, you had, the public policy bucket had become very, very wide, and you had multiple judgments, dating from Renu Sagar and successive judgments sort of expanding on the interpretation of public policy, which ultimately resulted in a very wide, scope for courts to actually interfere. So, you had Renu Sagar, which in the context of foreign awards defined public policy very neatly in three buckets. Fundamental policy of Indian law, interest of India, and justice and morality. However, many judgments that came later, where ONGC versus saw pipes, added a ground of patent illegality, which, meant ignoring vital evidence, ignoring terms of the contract. And as recently as 2014, you had the judgment of ONGC v. Western Gecko, where concepts like the Wednesbury reasonableness were added, as a supplementary ground almost, where an award could be set aside if, the tribunal's decision was capricious or arbitrary. So these, as the grounds widened, the standard of review, the scope of interference became more intrusive and almost like pretty much a review on merits. But what's important is that up until this time, jurisprudentially, there was no distinction between the two types of challenges, procedural and substantive, and they were all sort of decided on similar grounds. And similarly, there was no distinction between how, set aside challenges under 34 and applications to enforce the awards were decided. There was, it was all pretty much the same bucket. This sort of changed in around 2015 when there was an amendment to the law. In fact, the stated objective of the amendment was to ensure that there was no review on merits. So the test like Wednesbury reasonableness, etc., was removed and the grounds were tightened. Limited grounds, they tried to bring the definition of public policy more in line with the Renu Sagar test. In an international commercial arbitration, Sir touched upon that as well. The award could not be set aside on patent illegality. And even in domestic awards, where the ground of patent illegality is available to you, that was a very narrow determination. You could not, review the awards on merits. That for the first time, the Act actually says that, and so there was a very clear shift. Um, a- but but interestingly, in 2017, there was actually, for the first time, a shift in how the court started treating challenges under 34 and 48. And what you had, there were about 4 or 5 decisions of the Delhi High Court, which essentially said that there is a difference between jurisdictional challenges and those challenges which are on substance. And both those challenges cannot be dealt with in the same way. So there were decisions like, I'll name a couple: Cruise City versus Unitech Limited, Value Advisory versus ZTE Corp, where the courts relied on the UK decision in Dalla and essentially said that when there is a challenge to the tribunal's jurisdiction, the court would have to look at the issue de novo. There wasn't a very clear indication of what the de novo review would entail. Value Advisory said that the party should have an opportunity to introduce fresh evidence. But this essentially was the position in 2017. So and also currently where we are at, where essentially there is a clear dichotomy between the standard of review employed in an application under Section 34 and the standard of review applied in a jurisdictional challenge under Section 48.
Interesting. It's interesting also to see that the Delhi High Court seems to have taken that sort of proactive stance in distinguishing. If I could just ask a follow-up now from a comparative perspective, you've heard about the recent change in the UK amendments brought through amendments, and of course, Abraham touched about the pragmatic approach which Singapore has taken. At the same time, they're also contemplating discussing this issue by way of legislative amendments. Do you think, basis these changes in common law jurisdictions, which India follows closely, can we expect to see a shift in a legislative approach in India? We've heard of the amendments which were floated last year, but we haven't heard anything on the standard of review in those amendments.
So, I think the de novo review it's almost on a spectrum, as it were. On the one hand, you have the standard of review pre-2025 in England, where, it was based on Dalla. There was a wide right to introduce evidence. And I would say on the other end, you probably have Singapore, where there's no right to introduce fresh evidence. And India currently, at least as far as, Section 48 jurisdictional challenges are concerned, is probably somewhere in the middle. Where we're headed, Shreya, to answer your question, I think the 2019 amendments to the Arbitration Act are very telling. So if you look at how Section 34 read pre-2019, the section was prefaced with, and the arbitral award may be set aside if the person, on jurisdictional grounds, if the person making the application furnishes proof that any of the jurisdictional defects exist in the award. This was deleted by the 2019 amendment and replaced by the words establishes on the basis of the record of the arbitral tribunal. So there is a very clear shift in 34 that no, we're not going to allow fresh evidence. Of course, there isn't any indication on what the standard of review will be. But if you read that with the sort of lack of judicial precedent on the issue, I would say when 34 jurisdiction challenges are concerned, the legislator doesn't seem to want to change things up. And as far as courts are concerned, there are a few, pending decisions where this issue may likely be decided, but how and what way that'll go, your guess is as good as mine. As regards Section 48, there hasn't been a similar amendment. So, for enforcement challenges, a party can still sort of furnish proof in respect of jurisdictional challenges. Now, what proof includes is, I think, it isn't sort of the, Dalla, it doesn't stretch as far as Dalla expected it to. And there is some sort of indication in various judgments of the Supreme Court, and one particular judgment, the judgment in MK Global, sort of explained how this would work. And a party would certainly not have the right to sort of conduct a fresh trial at this stage. But if there is some evidence that for some good reason could not be presented before the tribunal, the party has the right to present it in an affidavit, and the court will decide the issue based on the affidavit without affording the parties a chance of cross-examination unless absolutely required. So de novo in its extreme form, I don't really see that happening here. At least for section 48, we're moving towards extreme deference to the tribunal, and section 34 is an entirely different matter.
Thank you. Thank you for that. And if I could now just request Justice Rao to sort of summarize the takeaways for us from this theme. We've heard about de novo review being a spectrum where, in its most extreme form, it looks like fresh evidence can be allowed, a complete rehearing can happen, etc. And then you have a more deferential, pragmatic approach where you don't go as far in terms of questioning how the tribunal ruled on jurisdiction. Do you see a comfortable middle ground between these extremes that countries such as India can adopt?
As Kanika was saying, that our act does not contemplate a de novo hearing. We have section 16 in our act where applications are filed before the tribunal about the jurisdiction of the tribunal on various grounds. And as an arbitrator doing domestic matters, we see every third or fourth case there is an application filed under section 16. And as is followed in other countries, the parties have to wait till the award is passed because there is no appeal provided against an order passed under section 16 dismissing it. Even when the matter goes to court, and when an application for setting aside the award is filed, there is no way a party can insist on a de novo hearing in respect of a jurisdictional objection. That's also heard on the basis of the material that was produced before the arbitral tribunal. And as Kanika was saying, there's only a slight indication in section 48 where the court has divided the grounds in section 48 for enforcement of a foreign award into jurisdictional objections, into objections for public policy, and into objections where a party might have been affected by a notice not being issued, etc. That's the maximum that has been done. And there's no indication also in the recommendations made by the T.K. Vishwanathan committee as to what is the move that they're making by introducing a provision for a de novo inquiry. But one aspect which is considered by them in the recommendation made is that an appeal has to be provided against an order that is passed by the tribunal under section 16 dismissing the objection during the arbitral proceedings itself instead of waiting till the end. But the middle path, as you were asking me, I think, is the Singapore path. Even Dala has been watered down now by the 2025 Act, where there are limited circumstances in which a de novo inquiry is done, even by the 2025 Act, amendment of section 69. But under the Singapore Act, as Abraham was mentioning, a party has to show to the court as to why evidence has not been led before the arbitral tribunal in respect of jurisdiction. So I think that should be a middle path.
Yeah. Thank you, sir. With this, we move on to sort of the concluding theme of today's session. No discussion on review of awards can be complete without talking about the recent Supreme Court decision in Gayatri Balasamy, which went into the question of whether a curial court can modify arbitral awards under Section 34 of the Indian Arbitration Act. We are all very familiar with the decision. We've read a lot of reports on it. So I won't introduce the facts and the reasoning in detail, but jump straight to some questions on it. Justice Rao, if I could again sort of request you for your views on the decision as a whole, but especially the question of whether you think it strikes the right balance between competing considerations such as consent of parties, finality of an arbitration proceeding, and efficiency.
Though modification of an award is existing in various well-developed jurisdictions where courts are given the power to modify, the 1996 Act categorically deleted such a provision which was there in the 1940 Act. The 1940 Arbitration Act permitted modification of an award by the courts, which has been expressly deleted in the 1996 Act. And I personally feel that the majority was not correct in saying that an award has to be modified. The majority was struggling to balance between principles of equity and justice, and on the other hand, what it says, jurisdictional fabric of Section 34. When the legislative mandate is that there cannot be a modification or a variation of an award, introducing such modification through a judicial verdict is not permissible, is my personal opinion. You were asking everybody as to whether they have read, or all of you must have read Gayatri Balaswamy, but I'm not sure whether you know the facts of the case. Gayatri Balaswamy was working with ISG Novasoft about 20 years back, 2006. And 2006, she filed a case of sexual harassment against certain superior officers. 2007, her services were terminated. And there were cases filed of extortion and defamation. Then the matter reached the Supreme Court. The Supreme Court asked the parties to go for arbitration. There was an arbitral award in her favor for about 2 crore rupees to start with. 2 crores is about 230,000 US dollars. The matter went to the court in Section 34. It was reduced to 1 crore 68 lakhs. The matter went to the division bench. It became about 60,000 rupees because the courts proceeded on the basis that they had the power to modify the award. When the matter reached the Supreme Court, you saw the Supreme Court judgment in the Constitution bench. But she has not got any relief till now, 20 years. When people go for arbitration, apart from anything else, they want finality to their dispute. When party autonomy is the basic rubric of arbitrations, when people want arbitrations to be conducted in an efficient manner, you cannot let a party go to a court and get a modification. You have a second rung of an appeal before the High Court and then thereafter the Supreme Court, and every court keeps modifying the award. I think that is not what is contemplated even by the legislature when it said it's only an award which can be annulled. I understand that the majority was of the opinion that this would save a lot of time and expense to parties, because once an award is nullified, then the parties are put back to the position before in which they were situated before the dispute started, which would mean that they would have to start the arbitration all over again. These are considerations that are taken into account by the division bench. But the division bench definitely did not really help in interpreting Section 34 of the Arbitration Act by only taking into these considerations, but giving an opportunity to all courts in the country to start tinkering with the award. As I said when I was speaking on the first point, and I said even when I was sitting in the Supreme Court in a few judgments, the law is very clear. It's only the interpretation of the law that is becoming very difficult now. When there are several people who are not really trained. See, every judge in this country does every other job. It's not as if we have, like in England, you have a commercial court where judges only do commercial work. Here you take a district judge does criminal trials, he hears civil appeals, he'll also take up special court matters, and there is no uniformity of a district judge sitting only in commercial matters for a long time. We have commercial courts, all right, but still there are frequent transfers. So this is a problem in people not being able to understand the scope of what is the power that is given to them. The Supreme Court said that only in limited situations can the court modify. They referred to 3 situations, one of which is interest, which is a very important component. As I told you, the amount that is reduced now in Gayatri Balaswamy's case itself, it has become 60,000 rupees from 2 crores. We do not know what the Supreme Court is going to do with that. So this is only leaving the door ajar, which would give scope for arbitral awards not becoming final at all. I agree with the minority view of Justice Vishwanathan that the court has to stick to what the legislature says, and then we cannot do whatever is contrary to what the legislature has said. That's my personal view.
Thank you, sir. That was very insightful. Um, as you touched upon the fact that the text of the Indian legislation actually is silent on whether there's a power to modify, and in that sense, only gives the option of setting aside or upholding the award. But the court still found interpretive routes to say that, look, yes, it can be modified, but in extremely limited circumstances. Sudhanshu, one of the things the Indian Supreme Court did was to actually consider the position in the UK and Singapore, and the fact that in some of those instances, the statute actually provides for modification. Could you tell us what is the position today under English law on whether a supervisory court can modify arbitral awards, and in what situations is that allowed?
Yeah, I can deal with this quite quickly. There's no general power in the English court to modify or vary an arbitral award. The 1996 Arbitration Act provides that where there is a successful jurisdiction challenge under Section 67 or a successful appeal on a point of law under Section 69, then there are a range of remedies that the court can give, and one of those remedies is varying the award. The other remedies include confirming the award, remitting the award to the tribunal in whole or in part for reconsideration, or setting aside the award in whole or in part. But depending on the exact facts and the precise respect in which the court said the tribunal erred, then variation might be one of might be the option it goes for.
And it's only limited to that specific section. Interesting. Ibrahim, if I could now come to you for the Singapore position, where do you stand on this issue? And as a separate follow-up, insofar as enforcement of awards is concerned, what issues do you foresee with enforcing arbitral awards which are modified subsequently by the seat courts?
Okay, so in Singapore, the position is quite clear. A supervising court only has the power to uphold the award, set aside the award, or remit it back to the tribunal for reconsideration. Our courts do not have the power to vary or modify the award. So it's quite clear for us that under the IAA, that's the position. The position taken by the Indian Supreme Court, let me say with respect, I agree entirely with Justice Rao's analysis. And I'll give you additional reasons why the position that Justice Rao is taking is, in my opinion, the correct one. One issue is this: how do you enforce internationally an award that has been modified by the seat court? If you look at the New York Convention, I think it's Article 4, it talks about how if a party wishes to have an award recognized and enforced, it has to supply a certified true copy of the award and a copy of the arbitration agreement. There is, in the language of the New York Convention, no possibility of submitting for enforcement an award together with a seat court judgment that has modified that award. So the question you're faced with is, when you're trying to enforce a modified award made out of India, outside of India, how is the enforcement court going to take to it, right? And my submission is, at least in Singapore, I doubt that the court is going to find that it has the power to enforce such an award. Even if, in theory, a court entertains the possibility of enforcing such an award, in my opinion, again, is subject to public policy concerns and due process concerns. For example, was there sufficient due process given to the other party at the seat court hearing? There's a question of whether there is a breach of party autonomy, i.e., is this the approach that the parties had signed up for? Or were they, when they were seeking to arbitrate the matter, expecting the matter to be decided on the substantive merits only by the tribunal? So I foresee the specter of inconsistent judgments globally in response to any attempts to enforce an award that has been modified by the seat court.
Yeah, increasingly leading to more complex issues. And Kanika, if I could request you to wrap up your takeaways from this theme, given the increasing complexity now of cross-border disputes, we heard about the risk of conflicting decisions on enforcement, set aside, and now modified awards being thrown into the mix. What practical steps do you think parties can take to ensure there's more predictability? And is there a way in which arbitral institutions and arbitrators can contribute to reduce the need for judicial scrutiny?
So, of course, cross-border disputes inherently expose the arbitral award to multiple jurisdictions. You have your seat court enforcement in some cases, different places where your interim application would be filed. And of course, there's a risk of inconsistent standards. We've seen that in the panel with just 3 jurisdictions in play. And from a practical perspective, there are a few things that the parties themselves can do. A few are very obvious. Be very deliberate in choosing your seat. In your, at least then there's predictability where your seat is concerned. You're setting aside arbitrations, modification. In similar way, in choosing the law of the arbitration agreement, choosing your governing law, these laws will invariably come into play when your setting aside application is being heard, and leaving no ambiguity on that front is just going to eliminate those aspects of litigation. And third is sort of building in institutional rules that provide for scrutiny of awards, and which provide mechanisms that enable parties to approach the tribunal itself to correct errors. So you have institutions. I mean, the MCI has procedures inbuilt. The SEAC has procedures inbuilt where a party can approach the tribunal to correct certain types of errors, computational errors, typographical errors. These sort of will reduce the risk of your, annulment challenges. And lastly, it's slightly harder in practice, but this is something that we try to do when our, corporate partners approach us and ask for help when we're drafting arbitration clauses. But, you try to sort of anticipate where your enforcement challenges will lie, where your award will be enforced. Try to identify your counterparty's assets. That way you'll get some sense of what your enforcement record of that particular country looks like. And you'll be able to map out at least vaguely what a dispute would look like under that agreement. Now, obviously, it's not possible to preempt every potential issue, but predictability comes with foresight, and these are the sort of things the parties should do actually to ensure that you're as dispute-proof as possible.
Thank you, Kanika. These are very helpful and practical suggestions we can all take away. We are past our time limits, and therefore, if I have the permission of the organizers, we can just take one audience question, if there's any. If anyone has a question to our panelists on these topics. Okay, I think we have a very disciplined audience, so time to wrap up and head for the drinks. Thank you, everyone, for your excellent and enriching insights into these issues. I think you've done a commendable job in navigating and breaking down these very complex issues into sort of key takeaways that our audience can take back for future. And I'd also like to thank the MCI and the organizing committee for their tireless efforts in organizing the ADR Week, which has now become a highlight for the Indian arbitration community. Thank you.
Thank you very much for an interesting session. This brings us to the end of day 2 in Mumbai for the India ADR Week. We will be having a short break, following which we will be having a short session, a short inaugural session for the IPBI arbitration days. After which, at 7 p.m., we will be having a keynote address by Justice Revati Dere, and then drinks and dinner later. So I would request you all to stay back. Thank you.